Good morning, everyone. So it is 10 o'clock, and just to respect everyone's time, we'll get started right away. I know we'll probably have a few more pop in throughout the webinar, but we'll get started right away. So on behalf of the Association of Ontario Road Supervisors, we're proud to recognize and celebrate National Public Works Week, a time to acknowledge the essential services that public works professionals provide every day to keep our communities safe, healthy, and functioning. This year, AORS is marking the occasion by hosting the week of informative and engaging webinars focused on the many aspects of municipal public works. We invite you to join us throughout the week to learn, share, and connect with peers across the province. Most importantly, we want to thank each and every one of you, our public works professionals, for the dedication, expertise, and hard work you bring to your roles. Whether you're maintaining roads, managing infrastructure, operating equipment, or supporting vital services behind the scenes, your contributions make a meaningful difference in the lives of every Ontarian. So thank you for all you do, and happy National Public Works Week. And I'm going to take the time to introduce Jaden Hodgins from Intact Public Entities. He is our guest speaker for the webinar today. It is going to be tight for time. He has a lot of information to share, and I think it's going to be tight to keep it to the 1 hour limit. So what Jaden and I had discussed before is if you want to put questions that you have for Jaden in the chat throughout the webinar, we will use those questions to create an FAQ page that we can send out to all participants after the event. So as you have questions throughout it, just put those into the chat, and then we will get all of those questions answered for you over the next few days. So with that, I am going to pass it over to Jaden.
All right. Thank you, Kelly. Good morning, everyone, and happy National Public Works Week. I'd like to say thank you to all the public works professionals for everything you do every day. It's great to have this week to acknowledge you and all the important work you do. I'd like to quickly thank everyone at AORS, President Carla, Kelly, Christy, and others for putting together these webinars. My name is Jaden Hodgins, and I am a road specialist with Intact Public Entities, and I'll be doing this presentation on risk management for public works. Yeah, as Kelly said, please, any questions you have, post them in Zoom
Morning,
and
chance
we'll
making.
get back to those.
Right.
And Kelly, maybe you can just mute anyone that's has their mic unmuted.
Will do.
All right. So here's the agenda for the presentation. I'm going to start off by providing an overview of municipal liability in the MMS, and then we're going to jump into some risk management considerations for the summer season, things like trips and falls, potholes, traffic signs, pavement markings, and road design. So I'd like to start off by setting the foundation for everything we'll be discussing today, and that starts with Section 44 of the Municipal Act. Section 44 of the Act deals with maintenance of highways, and what it says is that the municipality that has jurisdiction over a highway or bridge shall keep it in a state of repair that is reasonable in the circumstances, including the character and location of the highway or bridge. It continues on to say that if the municipality defaults in maintaining that reasonable state of repair, then they're going to be held liable for all damages any person sustains as a result of that default. So to boil it down, as a municipality, you have to maintain your roads and bridges in a reasonable state of repair. If you don't, then you're going to be held liable for any damages or injuries sustained as a result. So next important item to address is what constitutes a reasonable state of repair. There's no simple definition. It depends on many factors. For a road, it depends on things like the location of the road, its history, its character, its traffic volume, whether it's paved or rural, its normal usage, and the resources available to the municipality. And additionally, when the courts are assessing whether a road is in a state of repair or not, they will look at all of the facts and evidence and information available in making that assessment and determination. What we can learn from case law, however, is that the most important thing for a municipality to do to maintain a reasonable state of repair is preventing or remedying conditions that create an unreasonable risk of harm for drivers. And the application of these principles go way back to at least the 19th century, as shown in this quote from Chief Justice Armour from an 1898 road liability case that said the road is in a reasonable state of repair if users can pass to and fro upon it safely. So you may be wondering, how does the MMS fit in with this? And we will get to the MMS shortly, but it's important to note here that the MMS are not what is used to determine whether the road's in a state of repair or not. As we covered in the previous slide, determining reasonable state of repair comes down to whether the municipality has satisfied its duty to prevent conditions that create a risk of harm to road users. The purpose of the MMS are to provide municipality with a defense against claims of non-repair. So you may have heard that phrase that the MMS is a shield and not a sword, which means that it can only be used as a defense and not the other way around. So your municipality cannot be sued because you didn't meet the MMS. There's no legal basis for that type of action. And we'll get back to the MMS shortly, but we're going to continue discussing liability in a bit more detail. I'm going to spend some time discussing this four-step test that the courts use to assess municipal liability because it's very important. The four-step test was established through case law, and it's the framework that the judge will use to analyze whether the municipality is liable for road non-repair. The first step is non-repair, and the plaintiff, that is the injured party who is suing, must prove on a balance of probabilities that the municipality failed to keep the road in a reasonable state of repair. So the onus is on the plaintiff to establish that the road was in a state of non-repair first. If there's an action before the court and the plaintiff cannot establish that non-repair existed, then their case is going to fail. The next step, the plaintiff, again, must prove that the non-repair caused the action. And the normal test for determining causation is called the but-for test. And it says basically, but for the negligent act or the state of non-repair, the injury would not have occurred. So if the plaintiff can prove 1 and 2, non-repair and causation, then the municipality is considered liable in the eyes of the court. The onus then shifts to the defendant municipality to establish its defense. So that's step 3 of the four-step test. And there's 3 statutory defenses available to municipalities to use against road non-repair claims. This is laid out in section 44(3) of the Municipal Act. And the act says that the municipality is not liable for failing to keep its highway in a reasonable state of repair if it can establish one of these 3 defenses. And they are A, the municipality did not know and could not have reasonably known about the state of repair. B, that the municipality took reasonable steps to prevent the default from arising. And for this defense, item B, the municipality must be able to prove that it took reasonable steps, which generally means that you have an effective program and system of inspection and monitoring and repair and maintenance in place and that you're following that. The third defense, item C, is the MMS. So if you can prove that you met the MMS, then you're not going to be held liable. And you only have to establish one of these 3 defenses in order to be held not liable. And we'll go through each of these 3 in a bit more detail, some examples. So section 44(3)(a), the lack of knowledge defense. There was a recent case called Hamilton Dawkins versus the town of Ajax, where the municipal defendant successfully established the defense using 44(3)(a). And in this case, a pedestrian tripped and fell on a sidewalk surface discontinuity that was greater than 2 centimeters in height. And just note, this is a stock photo. This isn't a photo from the case. The pedestrian then sued the town of Ajax, claiming the sidewalk was in a state of non-repair. The town had inspected the sidewalk the year prior and recorded that it was only a minor crack, less than 2 centimeters in height. It was not repaired, as the town's policy was to only repair surface discontinuities greater than 19 millimeters. So when it went to court, the trial judge applied the 4-step test. The judge confirmed that the plaintiff was able to prove the first 2 steps, non-repair and causation. So the 3rd step shifted to the town, who relied on the defense of section 44(3)(a). The town argued that there was no evidence of them having knowledge of the surface discontinuity greater than 2 centimeters, and there was no way that they could have known about the discontinuity. They had done their annual inspection the year before and documented that it was in a state of repair, and they had not yet completed their annual inspections for this year. The trial judge agreed there was no evidence that showed the town knew or could reasonably have known about the the trip ledge. Therefore, the trial judge confirmed the town established this defense and the action was dismissed. Before moving on, just a couple other takeaways from this case. On the good side, the town of Ajax, they had an effective sidewalk inspection program. Their supervisor of operations testified in court regarding the town's inspection procedure, explaining they hired summer students to walk all the sidewalks annually using GPS units, and the students would record 3 categories of service discontinuities: 0 to 6, 6 to 19, and 19 millimeters. Any trip ledge greater than 19 millimeters was painted orange and logged for repair. So the sidewalk inspection program was generally adequate and provided the town with good records that they were able to use to defend the claim. There were, however, a couple things the judge did not like. The first being that the town did not have a written policy for its sidewalk inspections, and they didn't have a written training program for its summer students. So this left the judge with some discomfort because the lack of policy and training program may suggest that the students may not have been doing the inspections properly. The second thing is that following the trip and fall, the town went and repaired the sidewalk panel without documenting it, without taking photos. So the judge suggested that this effectively extinguished evidence that may have been used in litigation. But fortunately, given all of the factual circumstances, this was not significant and did not affect the outcome of the judge's decision. And lastly, when considering the Section 44(3)(a) defense, the judge cautiously quoted another case which stated, "A municipality should not readily benefit from its own failure to document or circulate complaints properly," which means that a municipality cannot put its head in the sand or fail to document or ignore complaints. A complaint received means that the municipality has knowledge and therefore cannot rely on this defense. So hypothetically, in this case, if the town had received notice from the public or a complaint about this trip ledge, then they would not be able to use this defense because they have knowledge of it. So the second of the 3 defenses, taking reasonable steps, the municipality will not be held liable if it took reasonable steps to prevent the default from arising. Reasonable steps, somewhat subjective, and it depends on all the facts and evidence available. However, case law shows us some of the common interpretations of reasonable steps include things like having an effective documented system of inspection and monitoring conditions. Inspection and monitoring are crucial because you have to be out there observing your roads for conditions and hazards. And inspection and monitoring really is doing your due diligence and a hugely important part of the work you do in public works. Another part of reasonable steps includes taking steps to eliminate or reduce a hazard after becoming aware. So that means you're responding to hazards or deficiencies in a timely manner, which is very important. More hazardous items or higher priority roads or sidewalks would warrant a faster response than a lower priority location, which is entirely reasonable. And most importantly, always, is that you must have detailed documentation and records available to use this defense. You must be able to show and prove that you took reasonable steps to prevent that default from arising. Things like patrol records, maintenance records, work orders, daily diaries, policies, training records, etc., all hugely important for proving that you took reasonable steps. So again, here's a recent court case to demonstrate this 44(3)(b) defense. This case is called Mitten versus Ministry of Transportation, 2024. However, I should note, technically, this case did not fall under the Municipal Act and it's Section 44, but under the Public Transportation and Highway Improvement Act because it happened on a King's highway under the jurisdiction of the MCO. However, the principles are the same as those used in the Municipal Act, and the judge applied a modified version of the 4-step test: non-repair, causation, and reasonableness of repair. The judge noted that upon the plaintiff proving non-repair and causation, the onus shifts to the MTO to prove that their winter maintenance was reasonable in addressing the non-repair. So in this case, it happened on February 12th, 2015, approximately 8 a.m. It was a really cold day in Northern Ontario or Eastern Ontario. Miss Mitten lost control of her vehicle, entered the lane of oncoming traffic, and collided with an oncoming vehicle. Both drivers were seriously injured. The driver of the second vehicle sued Miss Mitten, and Miss Mitten commenced a third-party claim against the MTO and its winter maintenance contractor, alleging negligent winter maintenance. And of course, the MTO contracted its winter maintenance to a contractor. They had very detailed specifications, requirements within their contract. The judge applied the four-step test. Step one, non-repair. Based on the evidence, the judge found that the highway became partially snowpacked. There were two experts involved, one on the plaintiff side, one on the defendant side, but they both agreed that snowpacked roads create a danger for users of the highway. Therefore, the highway was deemed in a state of non-repair. Step two, causation. So there was no evidence that Miss Mitten was distracted or her driving skills were impeded in any way. It was a bright and clear day, albeit very cold. So on the balance of probabilities, the judge concluded that had the road not been partially snowpacked, she would not have lost control. Causation had been met. Step three, MTO's defense of reasonable steps taken. The judge noted that compliance with the minimum standards or contractual requirements does not provide the road authority with a complete defense. Similarly, failure to comply with those requirements does not automatically create liability. The judge said that the facts of each case must be analyzed to determine if reasonable steps were taken to address a state of non-repair. The engineering expert in this case, who had considerable experience in these types of cases, testified that the winter maintenance records produced by the MTO were one of the most complete sets of records he has ever reviewed. So they were able to get a very detailed timeline of all the events and decisions that were made. And ultimately, it appears that it was this completeness of the MTO's records and documentation that caused the judge to find that their winter maintenance operations were reasonable in addressing the state of repair. Therefore, the MTO was found not liable. There was some interesting debate in the case as to whether the maintenance contractor should have used sand instead of salt on the morning of the collision due to the temperature being so low. But the judge found that the contractor exercised reasonable judgment in its decision to use salt instead of sand. And also the MTO's contract and standards allowed for that professional judgment from the contractor. So the final outcome was that claim was dismissed. And the takeaway from this case, again, is that in order to use this defense of taking reasonable steps, you must have good documentation and records to back it up. And finally, the third defense under Section 44(3) is the MMS. And the only thing I'll mention here about the MMS is that in order to use it as a defense, you have to be able to prove that the MMS was met. So that proof is provided through documentation. So you should now have a better understanding of how the MMS fits into the legislative framework of the Municipal Act. Section 44, subsection 4 of the Municipal Act says that the Minister of Transportation can make regulations to establish minimum maintenance standards for repair of highway or bridges. So this enables the MMS to be created as a regulation under the Municipal Act. The MMS has been around since 2002, and it goes through updates every 5 years. The last update was in 2018, and there's a current draft amendment that was recently circulated by Good Roads and AORS and the MMS task force, and I believe it's gone on to the province now to be reviewed. They take a couple months to look at it. So as we have covered, the purpose of the MMS is to provide municipality with a defense against highway non-repair claims. And it's important to note that the MMS is not all-encompassing. It only applies to select aspects of the highway. So when it comes to the MMS, the importance of having good quality documentation cannot be overstated. There's that old saying, the job's not done until the paperwork's done. Very true in terms of MMS. And for defending claims and lawsuits, documentation is absolutely critical. If your municipality receives a notice of a claim, the first thing you're going to be asked for from the insurance people or the risk management people is for documentation. They're going to want to see your patrol records, your inspection records, maintenance records. And if you have good quality and complete documentation, you're likely going to have a good defense. Conversely, if you have poor quality documentation or you're missing documents, you're likely going to have a poor defense, and it may open your municipality up to additional liability. So documentation, it demonstrates due diligence and shows that you have procedures in place for inspection, monitoring, and maintenance. And as we saw with the 44.3b defense, documentation will also help show that reasonable steps were taken. A list of some best practices for documentation. Number one, make sure you're training your staff on documentation requirements. Your frontline public works staff must be trained on what the requirements are, which documents must be completed, when and how they're to be completed. And it's the responsibility of the managers and supervisors to ensure that your staff have this training and that they are meeting the requirements. Secondly, use standardized forms and templates. This helps ensure that you're collecting all the necessary information on your documents, and it helps with consistency. Intact Public Entities has a lot of excellent standard forms and templates on our website for Public Works. So if you're interested in those, have a look at our website or feel free to contact me. Complete records contemporaneously or as you go, and this helps ensure that information being recorded is accurate. We've seen in the past where the plaintiff's lawyer tried to cast some doubt on the accuracy of documents because they appeared not to have been completed contemporaneously. And also in terms of patrols and maintenance activities, it also helps to show exactly when something was started and completed. Issues such as exactly when a road was plowed or salted can be extremely important in cases where there's a motor vehicle crash. Use clear, unambiguous language. So this one's fairly self-explanatory, and an example would be on a sidewalk inspection, there's a surface discontinuity, and the inspector writes, appears to be less than 2 centimeters. Not very helpful. Was it 2 centimeters? Was it not? Be clear and unambiguous. Use measurements, numbers. Ensure consistency of records among staff. No matter what, your staff are going to complete records a little bit differently from person to person. So the supervisor or manager should review and sign off on this documentation and strive to have consistency with how all staff are completing their records. And lastly, maintain your records in an organized, reliable record-keeping system. When it comes to road liability cases, you may not find out you're getting sued until years later, so it's important that your records are maintained securely and in an organized way so they can easily be retrieved. Oh, and finally, we reached the 4th step of the 4-step test, which is contributory negligence. So this step will only come up if the municipality was unable to establish one of those 3 defenses. And the onus for proving contributory negligence is on the municipality. And what they're trying to prove is that the plaintiff's actions caused or contributed to their injuries. So if municipality can prove this, then it's going to reduce the amount of money owing to the plaintiff, depending on the amount of negligence contributed by the plaintiff. For example, if the damages were agreed upon at $1 million and the plaintiff is found 30% contributory negligent, then $300,000 of that judgment will be deducted, and they'll only be able to collect $700,000 of the $1 million. Some examples for drivers would be driving impaired, speeding, distracted, for a cyclist, not wearing a helmet, a pedestrian, wearing dark clothes at night. Those are all examples of contributory negligence. So that kind of wraps up that foundational information I wanted to provide on municipal liability. And just to recap, there's the topics that we covered there. And now I'm going to jump into some key risks and liabilities for public works summer operations. Here's the topics we'll cover: trip and falls, potholes, traffic signs, pavement markings, road design. And we'll start off with sidewalk trip and falls. So sidewalk trip and falls, very common source of claims. And here, since we're looking at summer, we're just going to talk about trips and falls as opposed to slips and falls on ice or snow, which are likely even more common and more severe injuries. As the name implies, trip and falls happen on sidewalks when a pedestrian catches their foot or missteps on a surface discontinuity or trip ledge. And we may think that trip and falls on sidewalks not really a big deal. However, The injuries and damages that occur in these incidents can be significant, leading to high claim costs, especially when you consider head or brain injuries. Theoretically, these sidewalk trip and fall claims should be simple to defend, and potentially each of the three defenses we looked at in Section 44.3 of the Municipal Act could be used by a municipality in defending the claim. But since the MMS specifically addresses sidewalk service discontinuities in Section 16.1, the MMS defense is a strong one, and if it can be backed up by good records of inspections and repairs and policies and procedures. So we'll look at some applicable court cases dealing with these types of claims. First one, a little bit of an older one, Bellfleur versus City of London. This happened back in October 2000, and the plaintiff was walking along the north shoulder of the street in the City of London. There were no sidewalks on the street, so and the shoulder was routinely used by pedestrians. The plaintiff stepped into a large hole on the shoulder that was covered by autumn leaves, twisted her ankle, and fell. Damages for the injuries were agreed to be $12,000. At this time in the year 2000, the MMS did not exist. However, the Municipal Act still had the other two defenses, being could not have reasonably known and took reasonable steps. Since the shoulder was commonly used by pedestrians due to there not being a sidewalk, the judge found that the standard of maintenance applicable to the shoulder approaches that of sidewalk. So when considering state of non-repair, unfortunately, the city wasn't able to establish a defense, and they were found liable for having failed to maintain a reasonable system of inspection of the gravel shoulders. In terms of contributory negligence, shoulders should be more careful than those using a sidewalk. However, the judge found that since the hole was filled with leaves, no matter how careful the plaintiff was, she would not have been able to see the hole, and it constituted a hidden trap. Therefore, no contributory negligence. The city was required to pay the $12,000 judgment. And just to pull some lessons learned from this, where there are no sidewalks and pedestrians are using shoulders or boulevards, you should have a system in place for inspecting those and maintaining those areas.
Mhm.
The next case we're going to look at is Voisin versus County of Oxford, 2022. This case involves the trip and fall that occurred in the town of Otterville in Oxford County in August 2016. So the main street running through this town was under construction, where the 50 millimeters of surface course of asphalt was milled out. The plaintiff was crossing the street at night when they tripped on the 50 millimeter milled edge, falling forward, breaking her arm. Damages for this case were agreed upon at $75,000. The four-step test for liability was assessed. So the first step for the plaintiff to prove that the road was in a state of non-repair. There was a really detailed look, I guess, from the plaintiff's legal counsel and the judge. They looked at all the facts, including the construction contract, the Ontario Provincial Standards specifications, MMS, Ontario Traffic Manual Book 7, human factors evidence, illumination. Ultimately, looking at all that information together, the judge concluded that the lack of ramping created a state of non-repair. In this case, they were not able to establish the defense. In terms of contributory negligence, the plaintiff was assessed 35% contributory negligent due to the fact that she lived adjacent to the construction project, was aware of it, and should have been taking more care walking at night through the construction area. County and contractor found 65% at fault. Fortunately, the county had the proper insurance and indemnity clauses in its construction contract, so the contractor was responsible for covering all costs associated with this, or their insurer was. And the lessons learned from this case, number one, ensure your construction contracts are properly set up with those insurance and indemnity clauses to protect your municipality from third-party claims. And secondly, when undertaking similar mill and pave contracts, consider ramping these trip ledges where pedestrians may foreseeably cross them. And one last one on sidewalk trip and falls. This one's an active claim. It's not gone to court. In this claim, the plaintiff allegedly fell forward over the sidewalk surface discontinuity, hit their head on the concrete sidewalk, temporarily losing consciousness. And in the action they brought against the municipality, they're suing for $1.1 million. Concussion, post-concussion symptoms, and psychological injuries can lead to these higher costs. The surface discontinuity was measured in 3 locations and ranged from 5 centimeters to 2.1 centimeters, so all exceeding the MMS threshold. And this one's unfortunate because the municipality had completed its annual sidewalk inspection per the MMS. They observed the surface discontinuity to exceed the 2 centimeter threshold. However, it was not repaired, so something fell through the cracks. And the lessons learned or takeaways from this claim are: one, that trip and fall claims can be significant, especially when head injuries occur. And two, you must follow up and ensure that your repairs are completed following inspections. Obviously, something went wrong in this case. Maybe there was a breakdown in the procedure between inspections and repairs. So you need to review your whole sidewalk inspection program, from training to inspections to repairs. And you need to ensure that it's working as intended. And lastly, spray paint surface discontinuities as soon as you become aware of them. Section 16.1, subsection 4 of the MMS says that treating a surface discontinuity includes alerting users' attention to the discontinuity, so that can help reduce liability as well. Just a list of some takeaways on sidewalk trip and falls now. Firstly, by having a well-documented program of sidewalk inspection and repairs and following it, you're showing that you have due diligence and showing that you're meeting the MMS. Secondly, in order for your inspection program to be effective, the inspectors need to be properly trained. They need to know how to measure surface discontinuities, how to document them, how to spray paint them, etc. And you should also have your training materials documented, so that you can prove that your inspectors were properly trained how to inspect, like we saw in that Ajax case. Use appropriate tools and methods for measuring surface discontinuities. In the past, IPE has typically recommended use of a combination square, and the procedure is outlined in one of our Center of Excellence articles you can find online. As we learned from the Bellflower City of London case, you should inspect and repair boulevards and shoulders where pedestrians are using them, similar to how you inspect and repair sidewalks. It's going to have a higher standard of maintenance. Repair deficiencies within 14 days. That will ensure you're meeting the MMS deadline and that your sidewalks are never falling out of a state of repair. And warn the public of any potential hazards. So if your inspectors do find a surface discontinuity greater than 2 centimeters, spray paint it, put some barrels up, warn the public of the potential hazard. Lots of great resources on Intact Public Entities Center of Excellence dealing with sidewalk trip and falls. So be sure to check those out. There's case studies, there's procedures, lots of good stuff. Moving on to potholes. As most of you likely know, I think we're maybe out of pothole season now, a little bit, or maybe you're still dealing with them, but potholes are a very common source of claims, especially in the early spring with the thawing of the ground and roads. An important thing to keep in mind with potholes is motorcycles, scooters, bicycles, they're much more vulnerable than cars and trucks. A certain pothole that may just damage a vehicle can have really major impacts to a motorcyclist. You might crash into it or lose control. So you want to be sure that you have a good program of inspecting potholes through your routine road patrols, ensuring that hazardous conditions are not arising. In terms of defending against pothole claims, the MMS is the most effective tool available to municipalities. If you can prove that you met the MMS in terms of potholes, then your roads are going to be deemed in a state of repair, and you have a full defense against claims. And again, in order to have that MMS proof, it's all about having proper documentation and records. Well-documented patrol records and maintenance records. You may have heard the statement before, municipalities are not insurers of road users against all vehicular damage. It's not reasonable to expect municipalities to maintain their roads in a perfect pothole-free condition. Potholes are going to form over time and they cannot be repaired instantly. One last point here is that because pothole claims and complaints are so common, you may want to consider having a standard response to explain the MMS and the municipality's procedures for ensuring it meets the MMS and how therefore the claim will likely be denied. Might save you some time. Looking at the maintenance standards for potholes in the MMS, there's a definition there within the MMS, and additionally in section 6 of the MMS, it notes that the surface area of a pothole does not include any area that's merely depressed and not yet fully broken through the surface of the roadway. So it's an important distinction there. There's 3 tables in the MMS for potholes in paved roads, potholes in non-paved roads, and potholes in shoulders. This table here on the left is table 1 for paved roads. And the deeming provision in the MMS states that if the surface area or the depth is less than in the table, then the pothole is deemed in a state of repair, which we know means no liability. So only when both the surface area and the depth meet the table will a pothole considered to be in a state of non-repair. And that's once the deadline passes after you become aware of it. So as previously mentioned, the most important thing about being able to prove that you met the MMS with respect to potholes, and this proof should be shown in your patrol records, where you record when you patrolled the road and check for potholes per the MMS. You need to ensure that you're patrolling your roads at the necessary frequency per the MMS requirements. And you should also ensure that your patrol staff are properly trained on how to inspect potholes per the MMS standards. You should measure potholes to confirm whether they meet the tables in the MMS. Although the MMS does allow you to perform a visual estimate to determine the surface area and depth, it doesn't hurt to measure them from time to time just to kind of get an idea of what those thresholds are. Measuring potholes may be especially important when you do receive a claim. This should be done as soon as possible, and detailed records should be collected. The more information, the better. Take photos of measurements, holding the camera in line with the measurement. Also, when a claim is received, you should gather as much information as possible from the person making the claim. This may be done by an internal staff person at your municipality or an insurance adjuster, but you want to ensure you're getting the date, time, direction of travel, type of vehicle, nature of the damage, etc. If it's found to be a valid claim, then you'll have to gather all of your records to assess whether you have a proper MMS defense. Here's a list of takeaways for potholes. Train your staff who are completing patrols. They need to understand how to inspect and how to record inspections. As we covered, the road patrols are your proof of meeting MMS, so you need to ensure that you have good quality records of patrols. Repair potholes proactively. You should have a program of inspecting and repairing potholes regularly. You shouldn't wait till they reach the dimensions in the MMS. Potholes should be repaired earlier and more proactively. When you find a pothole that meets the MMS dimensions, then ensure that it's repaired within those specified timelines to avoid potential liability. And be sure to have documentation or records showing when it was inspected and when it was repaired. And we briefly went over some pointers for measuring potholes. Ensure that when you do have to measure a pothole, you measure carefully and create good records of those measurements, including photos. And lastly, because pothole claims are so common, consider establishing a process for dealing with complaints and claims efficiently. All right, next topic I want to discuss is traffic signs and pavement markings. So from the insurance and claims side of things, it's very common to see traffic signs and pavement markings closely reviewed and scrutinized when dealing with motor vehicle collision claims. So the courts have determined that municipalities have a duty to install warning signs for hazards and unexpected and potentially dangerous conditions. This aligns with what we previously covered regarding reasonable state of repair, which is essentially protecting road users from unreasonable risk of harm. A sudden sharp bend in a road, for example, poses a hazard, and drivers have to be warned of it in advance. And this is an important point. Signs must be placed sufficiently far in advance of the hazard to give drivers time to see the information, process the information, and react to the information by reducing their speed, for example. And when determining which signs to use and how to use them here in Ontario, we commonly refer to the Ontario traffic manuals, especially Book 5 and 6, the regulatory signs and warning signs. Another important reference is Regulation 615 for signs made under the Highway Traffic Act. These are just some examples of those Ontario traffic manuals. The one on the left just shows typical stop sign layouts from Book 5. The one on the right shows height and offset locations for signs in general from OTM Book 1B. And very important to ensure your signs are properly installed in accordance with these Ontario traffic manuals. As we'll discuss in the next slide, when motor vehicle collision claims arise, these things are scrutinized in great detail. So when a crash occurs and the plaintiff is launching a claim or action against a municipality, it's very common that they will hire an engineering expert to support their case. So their engineering expert will review the road condition in great detail, including things like the geometric design, traffic signs, pavement markings, pavement condition, sight lines, sight distances, etc. The engineering expert will prepare a report for the plaintiff summarizing the conditions, and any deficiencies in any of those features previously noted will be highlighted in the report. The plaintiff or their legal counsel will use these deficiencies against the municipality to strengthen their case. They may argue that the missing sign or the incorrectly placed sign contributed to the plaintiff's crash, or that it constituted a state of non-repair of the road. So this is another reason why it's so important to ensure that your traffic signs and pavement markings are installed in accordance with the applicable standards like the OTM manuals to reduce liability. Here's a list of some common issues I've seen with traffic signs and pavement markings, and I'll briefly go over them. Firstly, curve warning signs not being installed per OTM Book 6. Could be that the sign's not installed at all. It's not the correct sign for the type of curve. It's installed in the wrong location. It needs an advisory speed tab, or the advisory speed tab is not accurate. Since crashes on curves are 4 times more common than on straight sections of the road, it's important to verify that all your curve warning signs are correct. The next 2 items I touched on a bit already. However, for advisory speed tabs for curves, it's important that they are accurate and correct based on the physics of the curve. This is normally determined through a drive-through ball bank indicator test. Again, if the advisory speed is not correct or missing when it should have been there, then it's going to potentially create liability issues when the plaintiff's expert does the analysis after a crash happened. And I've discussed the importance of having the sign sufficiently far enough ahead of the curve or hazard. This is all laid out in Ontario Traffic Manual Book 6. Chevron signs and delineators, very common to see these missing where they should be installed or installed incorrectly. Either the spacing or the orientation may be incorrect. Again, Book 6 lays out the guidance for proper installation of these. Pavement markings, edge lines. Ontario Traffic Manual Book 11 covers pavement markings. It states that edge lines are required 150 meters in advance of and around all curves having an advisory speed less than the posted speed limit. So it's quite common to see these missing on curves with advisory speeds, the edge lines. And center lines, OTM Book 11, again, requires that center lines are required on all approaches to the crest of a hill where the available sight distance is less than 150 meters. So if you have some hilly roads with no center lines, be sure to look into that. On this slide, I just pulled out some commentary with relevant court cases that dealt with warning signs. The first case, Fordham versus Dutton Dunwich. Some of you may be familiar with that. It's a pretty famous case. And for those who aren't, I'll just recap it really quick. So this happened in 2007. Motor vehicle crash where a 16-year-old drove through a stop sign going 80 kilometers per hour in a rural area at night. On the other side of the intersection, there was a bend in the road and a concrete bridge, which the driver crashed into, suffering some major injuries. He sued the municipality for failing to post the warning signage on the other side of the intersection, warning of the bend. Obviously, he should have stopped. At trial, the judge found that the municipality was 50% liable because the judge said Rural drivers do not always obey stop signs, and the municipality ought to have known that. Fortunately, this case was appealed and the ruling was overturned because municipalities should not have to maintain their roads to a level to protect negligent drivers. So this case was very important in establishing that when assessing state of repair for roads, they only have to be safe for what's ordinary, reasonable drivers, not those who blatantly disobey traffic laws and stop signs. So with warning signs, not every hazard has to be signed, just those that would put an ordinary, reasonable driver at risk. So that's pretty important. The second case here, Greenhalgh versus Duro Dummer. In this case, two teenage girls were out touring backcountry roads in the winter when they got stuck on a back road. They ended up spending 12 hours in minus 20-degree weather, and one of the girls got very severe frostbite, leading to amputation of both of her feet and losing all 8 fingers. Ms. Greenhalgh sued the township for $12.5 million, arguing that the township breached its duty to warn the public that the road ended by not installing no exit signs and checkerboard signs. Experts got involved, and it came down to an analysis of whether the Ontario traffic manuals are a guideline or a legally enforceable standard. Unfortunately, the judge found that the Ontario traffic manuals are guidelines only. They do not establish a legally enforceable standard of care for civil liability. And the judge also took into consideration the budgetary and resource constraints of this small rural municipality. If it had to go and sign all of its dead-end roads and all of its rural roads, it would have been a significant undertaking for that very rural municipality. So the judge ruled that the township was not to blame and the action was dismissed. And this case shows us that just because you're missing a sign or not 100% in compliance with the Ontario traffic manuals, it doesn't mean that you're automatically going to be liable. The overriding question for assessing the state of repair of a highway is always, does the condition of the road pose an unreasonable risk of harm to reasonable drivers? And the lack of signs in this case did not. So to wrap up signs and pavement markings with some takeaways, number one thing to do, review your signs and pavement markings, ensure they meet the Ontario traffic manuals. Focus on things like warning signs, advisory speed signs, sign location, height, offset. Ensure you have the proper distance for the sign in advance of the hazard. And for pavement markings, based on Book 11, check whether you have center lines and edge lines where they're warranted, areas like hills and curves. Of course, inspect your signs for retroreflectivity annually per the MMS. And lastly, just a general note, do not oversign or install non-standard signs. Avoid clutter. Moving on to road design. In Canada, we typically reference the Transportation Association of Canada's Design Guide for Canadian Roads in our road design standards and best practices. This design guide is made up of 11 chapters and covers everything. I'm not going to list it because it's very comprehensive. When we see engineering experts get involved to analyze whether an existing road is up to current standard, this is often what they'll reference. The things we're going to focus on today are horizontal alignment, vertical alignment, shoulders. So the first item of road design, horizontal curves, or simply, curves and roads. It's important to consider road design for curves because crash rates are 3 times higher on curves than straight sections of road, and runoff road crashes are 4 times higher on curves. And additionally, more than 25% of fatal crashes are associated with the horizontal curve. And the vast majority of these are roadway departures or run off the road crashes. From a human factors lens, curves are more visually demanding for drivers, and this has been proven by studies of driver eye movements. When you're driving on a straight section, you maintain lane position by looking straight ahead and then using your peripheral vision to detect lane markings. On a curve, the current position and the future position are visually separated, so drivers are looking at both locations. It increases visual demand, and that adds complexity and difficulty to the task of driving, making driver errors more likely. If we go back to that TAC design guide, there are design criteria for curve radii based on design speed. So obviously, the faster the design speed, the larger the curve radius you need. And to put that into perspective, an 80 km/h design speed requires a 250-meter curve radius. And also, just generally speaking, the tighter or smaller the radius, the greater the risk generally. As crashes happen and claims come up, it's not uncommon to see that there are many substandard curves out there on municipal roads in Ontario. And just considering those two main factors, speed and radius, recognizing that it's not simple or feasible to realign a curve or adjust the road layout, it is much easier to post advisory speed tabs or look at reducing speed limits. Lastly, super elevation, another very important factor when considering horizontal curves. Super elevation reduces the likelihood of vehicles skidding, slipping, or tipping while navigating a curve. So this may be another factor to consider when reviewing your roads and your curves. Is there proper super elevation on that road? If not, then the curve may warrant an even lower speed advisory. And I just found this image online here showing some of the super elevations from NASCAR tracks. Not a big NASCAR fan myself, but interesting nonetheless. That middle one, 33 degrees super elevation at Talladega. So that's equivalent to a 65% slope, which is just crazy. And to put that into perspective, we go 6%, maybe 8% maximum, probably 6% for most of you guys. So yeah, 65% slope on that Talladega. A case here dealing with horizontal curves, Howson versus Nicolason. Very famous case, landmark case, not so much dealing with the curve details. It was more of like a legal technicality that took it all the way to the Supreme Court. But we'll just focus on the curve issue. This motor vehicle crash occurred way back in July 1992 in a rural municipality in Saskatchewan. On a rural road with an unposted 80 km/h speed limit. There was no warning signs or regulatory signs posted on this road. Again, this picture is just a stock image. It's not the one of the case. So Mr. Howson and Mr. Nicolason have been out drinking the night before and the morning of the crash. While driving through a dangerous curb section of the road, the back end of the truck slid out. The driver lost control. The truck flipped in the air, landing on the passenger side. And Mr. Howson, the passenger, was left paralyzed. So when it went to trial, experts were involved to assess the road conditions, and they found that the road was a hazard to the public. It was also what they called a hidden hazard because the sharp curves were not readily apparent to drivers. There was limited sight distance due to uncleared brush, which blocked drivers' view of the upcoming sharp right turn, immediately followed by a sharp left turn. The curve radius was surveyed to be 118 meters, whereas more like 250 was required. And the experts believe that the curve could really only be safely navigated at about 50 km/h. So given all of that, the trial judge found the municipality breached its duty to maintain the road in a reasonable state of repair due to its failing to erect warning signs for the hazardous curves. The plaintiff, Mr. Howson, was found 15% contributory negligent for failing to wear a seatbelt and for accepting a ride with a knowingly impaired driver. And Mr. Nicolason and the municipality were found jointly and severally liable for the remaining 85% of the damages. So some takeaways for horizontal curves. Number one, recognize that curves are a higher risk location for your road network. Those run off the road crashes 4 times more likely. And furthermore, recognizing that those run off the road and roadway departure crashes are 4 times more common, you should closely review your roadside design in these locations for safety. Are there fixed objects that may present hazards to vehicles that depart? Utility poles, trees, etc. Are there steep drop-offs that may warrant guardrail protection? We didn't cover roadside design or clear zones in this presentation. However, these considerations go hand in hand with curves. Review your sharp curves due to potential higher risks. Think about those less traveled roads as well, like those class 5, class 6 roads, like the one we saw in that Nicolason case. Drive those curves with attention, consider whether they may present hazards, and take steps to make them safer by installing warning signs or updating the speed advisory tabs. Ensure warning signs are installed in accordance with Ontario Traffic Manual Book 6. Review the standards and review the signs in the field. Make it a part of your inspections, make a special project out of it, do a 2025 review of curve warning signs. Some of the common things to verify, are they installed in the proper location in advance of the hazards per book 6? Are the advisory speeds signs, tabs, safe and realistic? If there's something you're not sure about, verify advisory speed signs by doing the ball bank indicator tests. And for curves on paved roads, you also need to ensure that you have the proper pavement markings per book 11. Review the standard and review the conditions in the fields. Again, make a project of it and go and get it done. Vertical curves. I have about 10 slides left. I see we're 5 minutes. We might go a little bit over, but I'll try to just get through the rest of this quickly. Again, if you have any questions, throw those in the chat, and we're going to put a little Q&A together afterwards. Vertical curves, especially hills, also known as crest curves, visibility and sight distance are very important. Stopping sight distance is the distance the driver needs to be able to see to stop their vehicle before hitting an object or another vehicle. And it's the most important factor for stopping sight distance is the vehicle speed. So the faster the vehicle, the more distance required to stop, the more the driver has to be able to see ahead. And I've seen multiple claims and lawsuits where crashes occur at the crest of hills where sight distance is deficient. One car veers into the other lane, and due to the lack of sight distance, there's no time for either vehicle to react in time. Distracted driving. Seen roads with 80 km/h speed limits with hills that they're so steep they're only really good for like a 40 km/h speed limit. So think about your municipality. If you're aware of any roads with steep hills, potential sight distance issues, and where speed limits may potentially be too high. Obviously, again, it's not really feasible to realign these roads, realign these vertical curves due to the cost that would be. So common low-cost remedial measures, speed limit reductions, centerline painting, warning signs. You can remind drivers to keep right. Yeah. And here's a case that happened in August 2004, another pretty famous case, when a vehicle driven by a 19-year-old woman with passengers lost control of her car on a hilly rural road. The crash happened at night when the road was unlit. She came to the crest of the hill. She was momentarily blinded by the headlights of an oncoming vehicle, and she thought that the vehicle was coming right at her. So she veered to the right into a ditch. The car rolled and then hit a rock culvert. There was two sisters. One was driving, and they were both rendered quadriplegic in the case. The other passengers were injured as well. This case went to trial in 2010, and the court apportioned liability 1/3 to the driver and 2/3 to Oshawa and Scugog Township. And the judge concluded that the road was in a state of non-repair based on a series of factual findings that were supported by evidence. There was a dangerous deflection at the top of the road. It was unlit. The speed limit was too high given the sight distance deficiencies. No center line. You see the picture, there's a center line, but this is from Google Maps afterwards. So list of takeaways for vertical curves. Vertical curves with deficient sight distances are common. You may likely have some of these in your municipality, and they may represent a higher risk. So you may want to review these in more detail to see if any further review or design improvements may be warranted. Ontario Traffic Manual Book 11 specifies that yellow centerline pavement markings are required on vertical curves with stopping sight distances less than 150 meters. Roads with steep hills or rolling terrain may warrant speed limit reductions. In areas with narrow pavement widths and restricted sight distance, you can install those keep right signs. Book 6 provides guidance on this. And limited sight distance due to hills or rolling terrain may also warrant other warning signs like school bus stop ahead, intersection ahead, and hidden tabs. Again, book 6, that's your reference. Last topic I'm going to cover, road design shoulders. So the purpose of road shoulders are to provide a recovery area for errant vehicles, to provide a refuge area for stopped or disabled vehicles. They can be used by emergency or maintenance vehicles, and they provide lateral support for the roadway. TAC design guide has 3 categories for shoulders: being paved, partially paved, usually 1/2 meter in width, and gravel. An important consideration with gravel shoulders is shoulder drop-offs, which are included in the MMS. The maintenance standard in the MMS for shoulder drop-offs is 8 centimeters deep for a continuous distance of 20 meters or more, which must be repaired in 4 to 30 days, depending on the classification of highway. If the drop-off is less than 8 centimeters, it's deemed to be in a state of repair. And edge drop-offs can lead to run-off-the-road crashes, and they're particularly dangerous on the inside of horizontal curves. TAC Design Guide identifies design widths for shoulders, which are copied in that table on the screen. And as you can see, it ranges from 1 meter to 3 meters, from rural local to rural arterial roads, and in between widths for collector roads. So good to be aware of these design widths, especially for higher risk areas in your municipality or areas with known run-off-the-road crashes. And again, when a claim or legal action arises, engineering experts may consider how the shoulders on the road compared with these design values. Here's an example, a recent claim I came across. It's ongoing, but in this case, there's a catch basin structure which is installed directly adjacent to the traveled portion of the road in what may be considered the shoulder. Municipality didn't have a lot of information on this catch basin, other than that it was installed by the private property owner many years ago to drain their parking lot. Municipality had no written record of providing consent or approval to install the catch basin, and they didn't undertake any inspections or maintenance of the structure. They did, however, permit it to remain adjacent to the road within the municipality's road allowance. So it resulted in a steep drop-off, approximately 13 centimeters in height, from the paved portion of the road down to the catch basin frame. And what happened in this case, there was a person riding a motorcycle on the road. They allegedly came across a large stone or rock they had to swerve around, and then after maneuvering around the rock, they went to pull over on the side of the road and went right over this catch basin structure, and lost control of the motorcycle, crashed, had some pretty serious injuries. And the outcome of this case is to be determined, still very early in the claim process. But a simple lesson learned here is, inspect your shoulders for those obstructions, potential hazards, even long-standing things like this catch basin. Just because it's been there for a long time doesn't mean that it's safe or it won't attract liability. And here's some takeaways for shoulders. Be aware of those design widths and kind of compare that to what you have out there on your roads. Maintenance is very important for shoulders. You should have a program of regularly inspecting and monitoring your shoulders as part of your patrols, and a regular program of maintenance. Shoulders are addressed within the MMS. You've got shoulder drop-offs of 8 centimeters, and then potholes in shoulders are also addressed. And again, during your road patrols, you should be monitoring for these conditions and ensuring that the shoulders are kept in a state of repair. Inspect shoulders for hazards and obstructions. We saw that example of the catch basin, things like this, as well as signs, posts, utility poles. These areas should be kept clear and free from obstructions or potential hazards. And lastly, inspect, monitor, and repair shoulders to a higher standard if they're commonly used by pedestrians, ATVs, or off-road vehicles. We saw that Bellfleur case where the judge held the shoulder to a higher standard, and the city wasn't inspecting it and maintaining it. So we got through it all, not too far over time. There's just a quick recap of what we covered there. Oh, sorry, I do have more. Not much though. Just to tack a couple extra additional general risk management best practices. Establish internal procedures that align with the MMS. These show that your municipality acted reasonably and diligently to maintain your roads. Standardized procedures also set clear expectations for your team, ensuring that your public works staff know how inspections and documentations are to be done. Having the procedures is not enough on its own. You must also ensure that they're being followed through. We saw that sidewalk trip and fall claim where it was inspected but never repaired. So, you as supervisors and managers need to ensure that things are working as intended. Make sure employees have the appropriate training and understand internal procedures. And this should be an ongoing process of training, supporting, and mentoring staff, always working towards continually improving your team. Ensure proper documentation is being completed and retained. And this may mean from time to time doing an audit, just checking on the documentation you are producing and the quality of that, making sure it's good quality, and being done consistently. Always use detailed contracts with proper indemnity and insurance clauses. Your insurer should be able to assist you with that and doing those contract reviews. And lastly, when in doubt, reach out. Feel free to reach out to me anytime if you have any questions or you're uncertain about a matter dealing with road liability or risk management. And leverage those connections you make through your local AORS association and your neighboring municipalities. Connect with your local peers, share best practices. That's always great. Intact Public Entities, we're here to help. We provide a wide variety of value-added risk management services as listed on the left part of this slide. These are all free to you. Things like general risk management advice can be about literally anything. We have an extremely diverse team of experts, and we encourage questions about anything. I mentioned the Center of Excellence on our website. Amazing resource for best practices, templates, case studies, standard operating procedures, and we're continually updating that. Contract reviews, we have lawyers and paralegals on staff who can review your contract documents, make sure they're bulletproof and have the appropriate insurance and indemnity clauses. We do educational seminars. I'm available to come out to your municipality, your AORS association, do some education. It could be basic MMS and documentation for frontline staff, whatever you want. MMS compliance reviews and documentation reviews. These are great exercises where I can come meet with you, gather some example documents, and assess whether your documentation complies with the MMS requirements, where you might have some gaps and some recommendations for improvements. And lastly, road risk assessments, site visits. I'm always happy to come out to your municipality, review a particular road or problem area to provide some advice or recommendations. And just on the right there, some examples of some of the inquiries I've gotten recently. Can be anything. Always interested to hear what you got questions about. Here's a QR code that you can scan. It's going to take you to our education center. I'll leave it up there for a second. We got some more webinars coming up through the summer, and then we'll definitely do an MMS one in the fall, leading into winter season. So be sure to keep an eye out for those. And that concludes my presentation. So thank you everyone who attended. Thanks Kelly. Thanks AORS. There's my contact information. There's what topics we covered. We're a little over time, so I think, like Kelly said, we'll look at the Q&A and follow up with some information. Thank you.
Thanks very much, Jayden, for your time today, and thanks for you that have joined. As Jayden said, we don't want to take up any more of your time. I'll leave the meeting open for a few more minutes if you want to put some questions that you have in the chat, or else if you want to email me at kellyanelliott@aors.on.ca. We will work with Jayden and Intact and put together that Q&A and send it out to everyone who registered. As you also know, we recorded this, and over the weekend we'll have it posted on our YouTube. It'll go out, and the links will go out in our e-newsletter on Tuesday, so you can share this with others who weren't able to join today. So again, thank you very much, Jayden. We have webinars scheduled for tomorrow. There's one on women in public works and lessons learned in manufacturing to skilled to public works. And then on Friday, protecting our shorelands. So please feel free to join us for those as well. And again, have a happy National Public Works Week.